Everyone, this is Terry Fox, partner at Fox & Mogul. Today we're going to discuss the issue of a real estate broker's civil liability in the context of a residential real estate purchase and sale transaction. In Virginia, the standard contract developed by the Northern Virginia Association of Realtors, or NVAR, can be found online at the link shown on your screen. Clause 29D of the contract states, as far as the broker is concerned, that the buyer and seller acknowledge that broker is being retained solely as a real estate agent and not as an attorney, tax advisor, a lender, appraiser, surveyor, structural engineer, mold or air quality expert, home inspector, or other professional service provider. Broker may, from time to time, engage in the general insurance, title insurance, mortgage loan, real estate settlement, home warranty, and other real estate-related businesses and services. Therefore, in addition to broker's fee specified herein, broker may receive compensation related to other services provided in the course of this transaction pursuant to the terms of a separate agreement or disclosure. So, in circumstances where there's a dispute between the buyer and the seller, the question often arises is if there is a basis to hold the other party's real estate broker liable. First, it's important to note that a real estate broker has a fiduciary duty to the client, which includes the duty to exercise ordinary care in the performance of the broker's duties. This is established both under Virginia Code and case law, shown at the sites on your screen. In a typical residential real estate purchase and sale transaction, where the buyer and seller are each represented by their agents, the real estate brokers are generally not liable for many problems resulting from false statements they may make in a transaction under the so-called broker shield statute, Virginia Code 54.1-2142.1, which states, a licensee shall not be liable for providing false information if the information was provided to the licensee by the licensee's client, or obtained from a governmental entity, or obtained from a non-governmental person or entity that obtained the information from a governmental entity, or obtained from a person licensed, certified, or registered to provide professional services in the Commonwealth, upon which the licensee relied, and the licensee did not A, have actual knowledge that the information was false, or B, act in a reckless disregard of the truth. In other words, the statute contemplates that the real estate agent is simply a mouthpiece for his or her client and is otherwise not liable for any false information provided to the other sides, unless the agent had actual knowledge of the falsity or acted in reckless disregard of the truth. These are often material issues of fact that are case-specific. So if you are a buyer or seller of residential real property in Virginia, and you have questions about whether the other side's broker can also be held liable in any lawsuit against the other party, then please call us at 703-652-5506 to discuss your case. Thank you and have a good day.